People v. Williams.
Good afternoon, Your Honors. May it please the Court, my name is Stephen Berko, and I represent appellant Brandon Williams on behalf of the Legal Aid Society. With the Court's permission, I'd like to reserve 5 minutes of my time for rebuttal.
Yes,
Your Honors, the Appellate Division's affirmance of Mr. Williams' convictions, despite a finding of a clear Bruton violation, raises two straightforward questions for this Court to resolve. One, was Mr. Williams' fundamental right to a fair trial prejudiced by the Bruton violation? And two, should traditional harmless error analysis even apply?
What was the Bruton violation that occurred?
The Bruton violation was his co-defendant's identification of my client as the bouncer of the nightclub and describing a familial relationship with him. As the Appellate Division found, that supplied motive.
Is motive an element of any of the crimes charged in this indictment?
Well, Your Honor, motive isn't per se an element, but as this Court held in People v. Fitzgerald back in 1898, the investigation of all charges of a crime, in the investigation of all charges of a crime, it is competent to prove motive on the part of the accused for the commission of the criminal act. In this case, motive was essentially the glue that held the prosecution's case against my client together. Without it, the jury wouldn't have known who was the bouncer. It would be hard to understand. It would raise a reasonable doubt in the juror's mind why a bouncer would go out and vindicate the robbery of, say, some Ramden patron of the nightclub, why he would be so motivated to do that, as opposed to he himself was robbed and it was the nightclub owned by his cousin.
Well, in the statement, does it say that the bouncer got robbed?
What it says, Your Honor, excuse me, Your Honor.
It's okay.
Something like he violated my peeps.
Yes, exactly. He said he violated my peoples, my cousin, where I lay my head down at night. He acknowledged to the interrogating detective to the question of, are you saying, was it the keeper of the gate who was robbed, the one who takes money? The answer to that was yes. Not yes, who else?
Right, but I think he took great pains not to say anything. The way I read the statement, I don't know if there's another way to read it, he doesn't give the defendant's name, correct? He doesn't say there was even a second shooter. He doesn't say that the defendant was his bouncer. And I don't think he says that the bouncer got robbed. So I think that we're way outside the scope of Bruton, either under the Constitution or under our state constitution.
Well,
why am I wrong about that?
Well, Your Honor, what I would first do is, the way I would first respond to that is to cite this court to its own standard of how to determine whether a Bruton error occurred. This court says in Cedeno, and the Appellate Division here adopted that standard, the Bruton rule applies to statements that obviously directly refer to someone, often obviously the defendant, and which involve inferences that a jury can make immediately, even if the confession were the very first item introduced at trial.
But doesn't Cedeno also require a facially incriminating statement?
Well, Your Honor, there's no other way to interpret the answer, who else, other than yes, he was a bouncer. And I would draw this court.
Can we revisit the Bruton violation?
Excuse me, Your Honor?
Can we revisit that determination by the AD, that there was a Bruton violation? I thought your point was that what's before us is what are the consequences of the violation?
That is my point. I mean, we did offer argumentation that People against LaFontaine bars this court from addressing that question on grounds that a non-appealing party is seeking affirmative relief. But I will answer, of course, answer any of the questions, because the questions as it relates.
Just to be clear, that's your first position.
That is my first position,
But if the court
Your Honor.
disagrees with you,
Right.
you're arguing that there was a Bruton violation.
And I think it's very important to consider whether there was a violation or not. Well, I put it this way. I think it's important to understand the incriminating effect of the violation.
Doesn't it go to harmless error as well? I mean, put aside LaFontaine for a second. If it really isn't much of a Bruton violation, wouldn't that go to whether or not it's harmless?
Well, Your Honor, I wouldn't agree with that characterization of
Well, it would be
the
different in a
level of
harmless error than-
incrimination here.
I mean, if he had said, yeah, the guy was with me and we shot him, and he gives the name, and you'd have a much different harmless error analysis, wouldn't you?
In effect, he did that. I mean, this court,
You make a few inferences, and I mean, you were citing our
But
case.
these
we could
are not-
agree or I'm sorry, we could agree or disagree on what that case says, but clearly you have to make a few inferences, right?
I would think that where my client was sitting with only one other defendant at counsel table, and the prosecutor opened on summation, on opening statement said that you will hear the victim robbed one of his peoples. So instead of calling the police, these two defendants decided that Donald Reed had to die, and they meted out their own version of street justice. That essentially
That seems to me
meets the
to
standard.
indicate that the Peoples is not one of those two, the way that's phrased.
Well, the way that's, but the logic of when you consider the answer to the question, to the interrogating detective's question of, was it the bouncer? Well, who else? The logic of it is,
I thought you were going to read from
of
the...
course, it
I
was.
thought you were going to read from the summation, actually, where I don't have it in front of me, but the prosecutor, I think, said something to the effect of, you know, the reason that he didn't tell you the name is because this is his cousin.
Right, and in
that's the
fact,
only inference
I'll
you
read
can
it
draw
for you.
from the fact
I'll
that-
read it for the court.
That seemed a little stronger.
On summation, the prosecutor reinforced that Osuna's confession referred to the defendant, stating that Osuna admitted that his cousin was the person who worked the door that night, and that Osuna made the decision to grab his sidekick bouncer, who told him he got robbed, and they went out together and they set upon tactically this victim by running and shooting before a word was said. It would it would introduce a serious doubt that a bouncer would go out and shoot someone, having learned that some random patron of the club got robbed. I mean, most rational people, even working as a bouncer in that situation, would say, can I get you a beer? Here's my phone, call 911. Not, I'm going to go out and kill the guy who did that to you. I mean, that itself is something that really made the people's case.
But aren't you really asking for a rule if there's an alleged crime with several defendants, and a few of them are on trial, and one defendant makes a statement, that you're automatically assuming that the other people at the table are the people that are referred to in the statement without reference specifically to that person or without any strong inferences that it's that person? I don't see how, if we adopt what you're saying, there could ever be introduction of a co-defendant's statement with more than one person sitting at the table.
Well, Your Honor, I mean, that's a question this court has decided in cases of interlocking confessions. And I'm relying on this court's precedent in both Cedeno and Wheeler. In Wheeler, there were only two people sitting at the table. Wheeler can be found at 62 New York 2nd at 867. There were only two people sitting at the table, and that was a factor that this court considered in determining whether this statement was incriminating
Right, in
of
addition
the
to the
defendant.
specificity of that statement. And so now, are you arguing under the state constitution, or are you still arguing under Bruton? Because if you're arguing under Bruton, how do you reconcile the Supreme Court's decision in Samia?
Well, in the first instance, your question has two parts, Your Honor. Of course, I'd like to ask this court to base its ruling under the state constitution. Samia, I think, is a case that that supports us. Samia had to do with the adequacy of a placeholder instead of a co-defendant's name. But Samia specifically said, if there's no redaction and no instruction, then there is a Bruton violation. I mean, the logical corollary to Samia, where there was redaction and was instruction, is that in a case like this, where neither of those things have taken place, then there is a Bruton violation.
Would this have been a violation if the statement came in as is and the instruction was given?
Well, Your Honor, assuming the statement can be characterized
It came in right as is, as it came in, but there was an instruction given,
Well,
Bruton.
but then you wouldn't have a complete violation of the Sixth Amendment. I mean, Your Honor, with all due respect, that's sort of, if that's a hypothetical along the lines of, if my grandmother had wheels, would she be a trolley car?
Because I'm going to ask you another trolley car question, perhaps. So if that's the case, what's the effect of not asking for the instruction?
Well, Your Honor, there was no necessity for counsel to ask for an instruction here. This case has been completely preserved by counsel's motion to sever.
And then you never have to ask for an instruction when you lose that motion. That's a standing request for the charge?
I wouldn't characterize it like that. The way I would characterize it is in just the same way that the onus is upon the prosecutor to have asked for a redaction in the Bruton context, it's also the onus is upon them. They're seeking the evidence to be admitted to ask for the instruction.
Do you think there might be a reason why you don't want that instruction?
That really has nothing to do with whether they are allowed to admit this evidence in its form without an
Do you
instruction.
think once you get this ruling, the judge has to give the Bruton instruction unless otherwise directed?
Well, Your Honor, the ruling properly should have been, this evidence should have been excluded entirely. And that's another reason.
I'm sorry, we're merging things here. So once you got this ruling, what's the effect on the charge? So then you have to give the charge unless the defendant objects to the charge?
The way I would contextualize it is this, Your Honor, just to go back for a minute to your question about whether counsel had an obligation to ask for the instruction. Counsel's position was the evidence should be excluded entirely because it was directly incriminating. If you put the burden on counsel to ask for an instruction,
So I'm asking, what would the rule be then? So the burden isn't on counsel to ask for the instruction, so the default is error not to give the instruction if you've admitted the statement. That's the rule you'd like us to say.
Well, the rule is there's an error not to give an instruction. Directly incriminating evidence can't come in ever under Bruton, but if it's indirectly incriminating, then yes, if there's no instruction, there's error. I mean, this court has said as much.
What if defense counsel said, I don't want the charge?
Well, then it would be, I suppose it would be a waiver, but that wasn't the case. I'd like to draw this court's attention to its own decision in People against Adams, 21 New York
I'm sorry,
2nd.
you have a red light. You would take 30 seconds just to address the harmless error. I'd like to hear your view as to why it's not harmless, given the witness identification.
Why?
It's not harmless.
Well,
Right, your position, it's not harmless error, and I'm asking you, given the witness ID, why is it not harmless?
As I said before, it was the glue that held the prosecution's case together against appellant. Osuna implicated an appellant by identifying him as the bouncer, described a familiar relationship with appellant. The prosecutor used that identification to bolster the testimony of the witnesses. This court, in engaging its harmless error analysis, I would ask this court to be mindful of its recent decision in People against Mosley, where this court found that non-lay eyewitness testimony should be excluded because it's of dubious quality and it may usurp the fact-finding functions of the jury.
But what if all they're doing is being shown a video of someone they know and have observed recently, but also many times in the past, and say, yeah, that's them?
Well, I mean, for that to happen under Mosley, there had to be a prior ruling by a trial court, by the trial judge, a prior ruling of voir dire outside of the hearing of the jury as to the nature of the familiarity of the eyewitnesses with the defendant. That didn't happen here. And I would respectfully submit that this is a court of law, and as a court of law, this court is unable to make a finding of fact that the trial court simply didn't do. And so I would ask this court to exclude the eyewitness testimony from its harmless error analysis in the event that you don't choose to take a per se ruling. But I would also ask the court to consider its own decision in People Against Adams, a case that we submitted to the court on our main brief. That's at 21 New York 2nd at 397. In that case, exactly like this, there was a co-defendant's incriminating confession. The prosecutor made use of it on summation, and there was an instruction, but this court held it to be per se error. There is a long history in this
Was there an
court.
objection? I'm sorry, was there an objection to the prosecutor's statements?
I don't believe so. I can,
That's okay. I'll check. It's okay.
Thank you.
thank you, Your Honors.
Good afternoon, Your Honor. It's Chris Belericosa for the Office of Melinda Katz, the Queens County DA for Respondent. Just to address
Whose responsibility, once the court says you can have the statement, was the onus on the prosecution or the defense to request a limiting instruction?
Well, I think the onus would be on the defense, because normally if you want an instruction, you have to ask for it. I think the ideal situation would be when
Why would it not be on the people, since they were asking for the use of that statement?
Well, I mean, the statement on its face wasn't incriminatory at all, and all the arguments that we made during summation were mainly based on the trial evidence that showed, from the witnesses and the video, which showed that this defendant was involved in the crime. Now, when we got to the part of Mr. Osuna's self-defense claim, that's when we started arguing about motive, because that undermined his self-defense claim. So we were primarily using it in that respect.
If the limiting instruction had been given in this instance, would that have cured? If there was a violation, would that have cured everything?
I mean, I would have to say, I'd like to say yes or no to that, but I would have to say that there was nothing to cure. There was no direct incrimination, either directly or inferentially. So what...
Let's assume it is viewed that it was incriminating. Would the limiting instruction fix it?
Well, I mean, if it's directly incriminating, Bruton says that that's beyond the power of a limiting instruction to fix, right?
So in one of these cases where you have a document, let's say, and it's got a name, redacted a couple times, there's a bunch of cases like that, right? If in that case, a prosecutor in summation argued, the reason that you see these redactions here is because it names the co-defendant. Is that a problem?
In cases like Cedeno and Wheeler, this court determined that that was a problem, but here that's not what we have, because we don't have the naming or the redaction of anybody's name.
Well, you sort of do, because what the prosecutor argued in summation is that's why he didn't want to name the person he was with. He didn't want to tell on his cousin. He said, oh, I gave you enough. I talked about me. I'm not telling you about anybody else, but he admitted that his cousin was the person who worked the door that night. So the prosecutor seems to me to be using the omission in the statement to argue the reason that he didn't tell you the name is because it's his co-defendant, the same way you might have said the reason that this document has a name redacted from it is because it's the name of the co-defendant.
I think this argument needs to be viewed in a different light, because the prosecutor throughout her summation emphasized the close relationship between Mr. Osuna and Mr. Williams in order to show that they acted in concert. That close relationship was established by the trial evidence not subject to a Bruton analysis. So over here, I mean, she's literally saying that he didn't name an accomplice, but this is more in the context of they were acting together. They shared a close relationship, not so much to create a Bruton violation or say, yeah, he named somebody. She's literally saying that he did not name anybody.
And the reason that he didn't name somebody as the person who was the other person with him is because it was his cousin. That's what she's using the omission to argue the identity directly.
Well, it's not really like she's, I'd still say it's not like she's filling in a blank so as to undo an instruction or to undo a redaction or a blank space. I think when you read this in context, both here and throughout the entire summation, this argument goes more to the close relationship they shared and how that shows they acted in concert.
Can you have a Bruton violation through a comment by counsel, be it proper or improper during summation?
Well, usually that's when a prosecutor, as we were discussing, can either undermines an instruction or undoes a redaction or undoes any a sanitized statement and says, yeah, that blank, that's him.
Do we have a LaFontaine issue here? Can we actually revisit this question of whether or not there was a Bruton violation?
Well, yeah, because I think this case is in the same procedural posture as People v. Golo. In Golo, we got a favorable ruling from the trial court that something wasn't an exclusion offense under the DLRA. The appellate division reached that issue and said, no, it was not an exclusion offense, and this court reached the issue and said, and agreed with the appellate division. And here, we're respondent, both in Goldo and here, we're respondent, so I don't think there's any procedural bar to this court considering the issue, and just as a practical matter, they're asking, one of their main claims, besides their claim that this is a directly inculpatory statement, is that you need an instruction before you proceed to harmless error. But you also need error before you proceed to harmless error. So it'd be kind of strange to not address the issue on the merits first to decide if there's error before you proceed to harmless error.
Well, not, sometimes we'll say, assuming without deciding there's an error.
Right, I mean,
So
right.
so why is it not harmless?
Why is it not
Assuming
harmless?
there's an error, why is it not harmless?
Well, I mean, first of all, there's no case that says you need an instruction before you proceed to harmless error review. Second of all, this court, as in Cedeno, can consider the lack of an instruction in performing harmless error review. Third, given the eyewitness testimony and the video, that provided overwhelming evidence of guilt. Counsel mentioned Mosley. Mosley, in this case, have entirely different facts, because in Mosley, you had a detective who didn't even see the perpetrator on the night of the crime, saw him 7 months later for maybe 1 day inside a precinct, never saw him outside on the street. There was no change in appearance. There was really no need to have that lay testimony. Here you have two people who were very familiar with this defendant, both on the night of the shooting, many prior occasions. He was wearing a hood at the time of the shooting, whereas he was not wearing the sweatshirt at the time that they saw him. He grew his hair out, at least that was the argument made at trial, that he grew his hair out between the time of the crime and the time of arrest. So all these factors combined show why the admission of this statement, at least as to Mr. Williams, did not create error. I mean, it didn't create any error. It's not incriminating on its face. It mentions no defendant. It doesn't mention an accomplice. It doesn't even mention who the bouncer is. There's no explicit statement that the bouncer had motive. There's not even an explicit statement that the bouncer himself was robbed, because all Mr. Osuna says is, well, there were 2 or 3 people in the hallway. One of them got robbed. I wasn't there. I didn't see it. And then when he's pressed on it, he says, well, who else? Yeah, I would think so. And then ends with saying, but I really wasn't there. So he's not even saying that the bouncer was robbed. He's not even saying that this happened to the bouncer. What's also significant is what he says at the beginning of his statement. He says, in general, my house was violated and my people were violated, right? That can be used to craft a motive argument, and that's not subject to Bruton, because he's not talking about anybody. At one point, he's talking about his house. You know, Bruton doesn't apply to an inanimate object.
I'm
So
going back
that-
to what Judge Canatero, I think, might be getting at, and he can correct me if I'm wrong. Wouldn't the prosecutor's comments on summation go more towards a prosecutorial misconduct claim rather than being the genesis of a Bruton issue? Like for Bruton, are we specifically looking at a statement? Do you understand what I'm saying? Like,
Yeah, sort of.
If the
Yeah, I mean-
prosecutor raised an issue at summation, I think it's a prosecutorial misconduct issue.
I mean, she's commenting on something in evidence, and fairly
I'm
so,
not
so I don't...
suggesting it is or it isn't, but I'm
Right.
just saying in terms of, can we use that? Like, is that a separate silo, Bruton here, misconduct here, or can the two intertwine?
I mean, I think sometimes they intertwine, again, if the prosecutor says something that runs counter to the limiting instruction, if the prosecutor says something that adds something into the spaces, you know, redactions or blank spaces inside a statement. I don't think that's what the prosecutor did here. In fact, that's not what the prosecutor did here. Her main thrust of her argument, again, was look at the trial evidence. That's not subject to Bruton. That's why these two are guilty. Her main use of the statement was to show that Mr. Osuna had motive. He
you're-
went-
Go ahead, sorry.
No, go ahead, sorry.
So your comment about the redactions suggests to me you think that the prosecutor in summation can make something incriminating, you know, to fill in a few gaps, if you will, for purposes of Bruton that might not be if it was standing alone absent the summation, that it can tie those pieces together. Is that right?
I mean, some cases have mentioned the
I know you're saying not
prosecutor's
here,
remarks.
but you think that's relevant.
I mean, some cases have relied upon that. I don't know how totally relevant it is, because the prosecutor's comments are not evidence. They have the statement. And, you know, here, the prosecutor was mainly relying on the relationship to show motive. And I think that's fairly significant, Because without that relationship, you really can't show motive. If you take out everything about the robbery from the statement, you can still make the argument that, well, that's his friend, his buddy, his sidekick, his cousin, his bouncer. So he went along for the ride, regardless of the reason. She even said during her summation, it doesn't matter whether this robbery actually took place. So it's not so much the robbery or the violation here, it's the relationship. That's what the motive argument is based on. That's not subject to Bruton. That came out in the trial evidence from the testimony of the witnesses who testified at trial. Now, I mean, if you just have the violation and no evidence of the relationship, how are you going to craft a motive argument then? Then there's no connection. But without it, you can still craft that argument. And again, the beginning of the statement mentioned nobody, no specific person, not even a bouncer, just a violation of a home, robbery of one of his people, who could be anybody. That doesn't involve Bruton at all. And that's the first thing that the jury heard. By hearing that, they can't look to the defense table and say, oh, that's got to be the bouncer. Even upon hearing the part about the bouncer, they can't look to the defense table and say, oh, that's got to be him. He's not named.
But when
There's
you
no
phrase
description.
it that way, you kind of wonder what was the redaction supposed to be from the statement? Because we never actually got a redaction, right?
Right, the statement wasn't redacted.
So what would the proposed redaction have been? Did anyone specify what language needed to come out of this statement?
Well, what counsel, there was one exchange, I think it's at 649 to 670 of the record. The prosecutor noted that she had asked counsel, what do you want redacted, and he never got back to her about that. And this is before the statement came in, right before Detective Rodriguez's testimony.
I mean, in the classical situation, Bruton redaction paradigm, there's a name in there that you want to take out, and you substitute other person or something like that. There is no name in here.
Right.
So I'm struggling to understand, because I don't think it ever really gets developed in the record, what was supposed to come out of this?
I mean, I'm guessing that my adversary might say the part about the bouncer, but that part is not directly incriminatory. It doesn't make out an element of the crime. It doesn't fall anywhere near what Bruton says is the normal type of thing you take out a statement, right? It goes potentially to motive. It doesn't even actually go to motive, because Mr. Osuna never said with any definiteness, with any specificity, that the bouncer actually got robbed. He speculated. He said, I wasn't there. All right, so that part of the statement incriminates nobody.
If that's the only bouncer that worked at the establishment, the defendant was that only person, doesn't that clearly identify him as the potential victim of said robbery?
But even if it does, it's still not identifying him as a participant in the crime.
Do you know
It's
if the
still not
word
making out an
bouncer?
element to the crime.
I'm sorry, Counsel. Do you
Sorry.
know if the word bouncer appears in Osuna's statement?
They use a different term. They use keeper of the gate, and they use the guy at the door collecting money. So the term bouncer isn't used, that's used at trial. It's basically the same thing as a bouncer.
So, just so I'm clear, were specific redactions ever requested?
As far as I'm aware, no, there's nothing in the record that counsel ever said, before this comes in, we want this, that, or the other thing redacted. As far as the limiting,
It's just on that motive issue. They need not have been a victim, right? That's one motive, sure, okay. But certainly, the prosecutor is suggesting that part of the motive is also the relationship to the co-defendant, whose home and people who were in the home were violated, right?
right, but I think that argument is, I'm sorry, excuse me. I think that argument is mainly coming from the relationship. Because as I said before, you can take out everything about this robbery and you still have a motive argument, right? If you take out the relationship, how do you have the motive argument? You can't forge a link there, right? It's mainly based on the fact that he's the bouncer and his cousin. So let's say there's,
That was my point, right? That he doesn't have to be a victim of the robbery to have a motive. I think the prosecutor
right, he doesn't.
presented that.
Right, and that's a very good point. Just because somebody's ID'd as a victim, that's essentially what he's ID'd here as a victim or a potential victim. Being a victim of a crime doesn't make you a criminal. It doesn't make out an element of the crime, doesn't mean you're involved in the crime, right? It provides at most, at best, a potential reason for maybe acting, but it doesn't mean that you actually acted. Bruton's about if you actually acted, were you involved in the crime? were you one of the perpetrators?
I'm sorry, I thought that there was a redaction requested. I thought that there was a redaction requested to remove the portion of the statement that indicated that the doorman was the victim of the robbery at 350 to 352.
At 350 to 352.
Is that not accurate? I think it's after
I
the
don't-
exhibit's in, but before it's published.
Yeah, I mean, the only part of the record that I remember redaction came up was right before Rodriguez's testimony, because then counsel started talking about Bruton again, and the prosecutor said, I told him to give me any redactions, and he didn't. So maybe it was discussed earlier, but not the specific parts of the statement that should be redacted, right? I see my time is up. I'd just like to talk briefly about the instruction. I think it's assumed that Bruton requires an instruction because of the language of some of these cases. But if you look at Richardson, Richardson has a lot of language before it gets to the holding where it says an instruction is only more likely to prevent error. It's only more likely to work when you have, inferential incrimination. But that doesn't mean that counsel has to go by that. Just because courts presume that, that doesn't mean that a defense attorney, as a matter of strategy, can't say, well, I don't want this judge pointing out this statement about my client. I'm not going to buy into that. I don't think it is going to make it more likely. I think it's going to highlight that statement for the jury. Richardson also says that an instruction is a reasonable accommodation. That's all it says about it. It's a reasonable accommodation between the interests of the defendant and the interests of the state. Why shouldn't counsel be able to turn down that reasonable accommodation? I think a big reason why the instruction wasn't given here.
Defense counsel be required to fix what they perceive to be a clear error to the benefit of the people?
Well, a clear error in the admission of the statement.
If in fact it were, they believed it to be an error, is it their responsibility to fix it? Or is it the people's responsibility, just in case, to make sure the request is made? Why is it their responsibility in the first instance?
Well, I mean, it's sort of a difference in perception. I mean, we saw no problem with this statement.
Right, and
There's
you
nothing to
asked for the
request.
statement, and you got the statement.
Right, exactly. But why?
They objected.
They made a
A
motion to
severance.
a severance
They made a
motion where they
motion to
raised
sever.
Bruton.
Yes.
Right, but on its face, and this goes to the judge as well, the statement didn't incriminate anybody, so it's kind of understandable why the judge didn't bring up an instruction, why counsel didn't ask for it, or it could have just been a matter of strategy. But if it doesn't incriminate anybody on its face, and even inferentially, it's not incriminating somebody in terms of ID or an element to the crime, then what do you need the instruction for? What is the instruction going to do? What is it going to prevent? It could very well have the opposite effect. Even Gray v. Maryland talks about that. Having an instruction can just turn the jury to that blank space and let them realize that the guy sitting there is the guy in the blank space.
Thank you.
Thank you, Judge.
Your Honor, just going to the last point about whether the statement was facially incriminating or not, I would I would ask this court to consider its decision in Cedeno and in Johnson, 27 New York 3rd at 60, that evaluated factors outside the strict statement that was the subject of Bruton and looked at the prosecution's use of the inadmissible hearsay and the context in which it occurred. Here, without even going to summation, the prosecutor framed the case with the testimony. As to the prosecutor's summation, in Your Honor's prior question, in Adams, from what I see, there was no objection. And in Adams, this court actually didn't even engage in harmless error analysis in the reversal. Rather, the court stated, although the evidence in the record is sufficient to support the conviction, this court, as well as others, has refused to announce a doctrine that the fundamentals of a fair trial need not be respected if there is proof in the record to persuade us of defendant's guilt. And
Counsel, can I ask you if you can point us to a case, either federally or state, where there's a Bruton violation found where a defendant's statement doesn't even acknowledge another participant in the crime?
Well, Your Honor, I mean, here I would respectfully disagree with you. He did acknowledge that what Osuna acknowledged was that his cousin, his Peoples, got robbed. And so in that, he informed the jury of a close familial relationship. He gave a personal motive to the bouncer. He himself was a victim, and a family motive to seek retribution. So whatever was missing from the statement was supplied by the prosecutor at opening. And so even before any evidence...
Isn't there a difference between the prosecutor having to prove their case, where they have to prove that two people committed a murder, right? They have to introduce evidence about two people. I'm saying this statement doesn't even acknowledge the presence of another co-defendant in this murder. So how do we find a Bruton error?
Well, Your Honor, I mean, I would respectfully disagree with that. The statement basically cannot be taken to be any other way than the guy sitting next to me was the bouncer, and he and I went out to shoot this guy because the bouncer got robbed. I don't see how any reasonable juror can interpret the statement any differently. I mean, it was, as I mentioned to the court earlier, the glue that held the prosecution's case together. Without this statement, you simply have two dubious eyewitnesses who looked at a videotape and without a prior hearing or a voir dire, according to what this court requires in Mosley, and said, oh, that guy was the bouncer. So you would have absolutely no idea who was robbed in the nightclub. I think any reasonable juror might wonder, given, let's say, the quality of the videotape and questions as to the credibility of the witnesses, a reasonable juror might wonder, would a reasonable nightclub bouncer go out and kill someone, a patron of the nightclub, just because he thought it was part of his job duty? I mean, it would be kind of hard to picture the job interview of a potential bouncer in that situation. Okay, so your duties will be to take money at the gate and to keep everyone generally quiet. But if I come and tell you that a patron was robbed, I expect you to take a gun and come with me and shoot the guy. I mean, that would be rather extraordinary. So that would introduce doubt into the case. But that doubt was effectively addressed by the prosecutor in opening statement. And as I've mentioned to the court, in Cedeno and Johnson, this court has looked to factors outside the strict content of the Bruton case. And in Wheeler, it looked at the fact that there were only two defendants at the table, as this case. And just to briefly touch on Judge Rivera's question about Gullo, on page 13 to 14 of our reply brief, we do distinguish Gullo, where we point out to the court that the threshold, the separate question there was a threshold question and did not involve two separate analytical tracks as this question that the people are submitting here for this court's review. I would also ask the court to consider what Bruton says. Bruton discusses the impossibility of determining what effect the incriminating evidence has upon the juror's mind. Bruton found that to be impossible and found that the evidence was inherently prejudicial. And I'm recalling something that I learned in my first year introduction to philosophy class as an undergraduate. Aristotle says in his laws of metaphysics, something cannot be itself and the opposite of itself at one and the same time. You cannot have a pot of water at a rolling boil and be at a block of ice at a one and the same time. Bruton says evidence of this nature is devastating in its effect and inherently prejudicial. So therefore, it is untenable to call that same thing harmless. It doesn't make any sense, and we discussed that in our brief, and unless your honors have any questions, I'll rest on my papers, and we would ask this court to reverse and order a new trial.
Thank you.
Thank you.